Good day and welcome to the Commission Business Meeting Conference Call. At this time, I would like to turn the conference over to Catherine Lehman. You may begin.
Thank you. This meeting of the U.S. Commission on Civil Rights comes to order at 10:01 a.m. on December 5th, 2019. The meeting takes place at the Commission's headquarters, which are located at 1331 Pennsylvania Avenue Northwest, Washington, D.C. I'm Chair Catherine Lehman, and the commissioners who are present at this meeting, in addition to me, are Vice Chair Timmons Goodson, Commissioner Degbele, and I believe Commissioner Harriet will join us shortly on the phone. If you could confirm that you are on the line after I say your name. I believe we have Commissioner Kirsanow.
Here.
Thank you. Commissioner Chladni.
Here.
Thank you. And Commissioner Yaki.
Aye.
Thank you. A quorum of the commissioners is present. Could the court reporter confirm that you are present?
Yes, ma'am.
Thank you. Mr. Staff Director, will you confirm that you are present?
I am present.
Thank you. The meeting now comes to order. Is there a motion to approve the agenda for this business meeting?
So moved.
Thank you. Is there a second?
Second.
Thank you. I'll begin the call for amendments with several of my own, starting with adding the presentations from the West Virginia Advisory Committee and the Alaska Advisory Committee on their recent reports and consideration of a statement of 2020 priorities for Congress. Is there a second for my amendments?
Second.
Thank you.
I second.
Thank you. Enthusiastic seconds. Are there any other amendments? Commissioner Chladni, I believe you have an amendment.
Yes, I do. Oh, I'm sorry.
Thank you.
Zoned out. I'm zoned out. It's early. It's early. Honest. I'd like to amend the agenda to take up a subject of a subcommittee for our sub-minimum wage project for site visits.
Thank you. Is there a second?
Second.
Terrific. Are there any further amendments? If there are no further amendments, let's vote to approve the agenda as amended. All those in favor say aye.
Aye. Aye.
Aye.
All those opposed say so. Any abstentions? The motion passes unanimously. We'll begin with one of our amended business meeting items to hear from the newly appointed chair of the West Virginia Advisory Committee, Lisa Yunis, on the committee's recent report titled Civil Rights Impacts from Collateral Consequences in West Virginia. Chair Yunis, I really appreciate that you came in person to join us, and we're looking forward to hearing your presentation.
Thank you. Thank you for the opportunity to present the West Virginia Advisory Committee report titled Civil Rights Impacts from Collateral Consequences in West Virginia. The committee chose this issue because collateral consequences compound the difficulties West Virginians with a criminal record have in relation to the already precarious economic status of our state, especially as criminal convictions occur from a burgeoning opioid crisis. The penalties after serving time as punishment for a crime are legal and regulatory. Often these individuals with a criminal record suffer from collateral consequences not directly as punishment for the crime, but because of their record. We focused on the economic consequences, those that exclude someone from economic reintegration, and reviewed laws as well as perceptions and misunderstandings that impose employment, licensing, housing, and public benefits. The committee held 2 briefings. The first one, an overview briefing by national experts highlighting the issues that would be covered. The second, a day-long in-person briefing that focused specifically on the impact of collateral consequences in West Virginia. There were 5 panels: housing, employment, occupational licenses, public benefits, and a legislative panel, or legislative response panel, excuse me. The day-long briefing included presentations by West Virginians who shared the challenges they face trying to reintegrate into their communities when accessing employment, housing, public benefits, and professional licenses because of their prior criminal records. The committee identified these persons as returning citizens. The committee chose to use this term to provide a name to individuals with a criminal record that would treat such persons with dignity and respect, and to suggest that such persons are due equal dignity with other citizens who do not have a record of arrest or conviction. This report advises the Commission about what the committee learned and its recommendations to address the impact that collateral consequences have on West Virginians with criminal records. In my summary today, I focused on several key recommendations recommended by the committee members who drafted the report. Under employment, the committee noted that employers' skepticism and suspicion about persons with criminal records is understandable in some cases, but where there is no relation between the job and the past crime, denial of employment poses a barrier. Unemployment is correlated with recidivism. Use of background checks has increased. Although liability insurance is available for employers who hire ex-felons, many employers are not aware of it, or if they are not convinced to take advantage of it. The committee recommended the West Virginia governor, 1, commission a study to review barriers to entry into the jobs market specific to individuals with a criminal record, including reduced access to training and apprenticeship programs, as well as financial aid for post-secondary education. And 2, direct the Department of Military Affairs and Public Safety to develop a work release program to help individuals with a criminal record transition to their community in a supportive manner. Under licensing, West Virginia has one of the highest unemployment rates and a very low workforce participation rate. Limiting occupational licensing stating public safety related to moral turpitude punishes our working community. The application process and lack of coordination between the various licensing boards are issues. Our committee recommended that the West Virginia legislature require licensing boards be diligent in collecting information related to a licensing applicant and in reviewing the application. For example, occupational boards should look at people on a more individual basis and remove vague language regarding what convictions can be considered and placing time limits on how far back convictions are considered. To note, earlier this year, House Bill 118 eased restrictions on many professional licenses for people with a criminal conviction and eliminated moral turpitude as a disqualifying standard in the licensing process. The use of criminal convictions to disqualify a person from obtaining a professional license will need to, quote unquote, bear a rational nexus to duties and responsibilities to the profession or occupation. Under housing, HUD allows for discretion for local public housing authorities to create policy. In West Virginia, family members can be denied housing or considered ineligible for housing benefits due to a felony conviction of a family member. The committee advised the Commission that the West Virginia legislature conduct a study to provide targeted funding to encourage public housing authorities and private property owners to offer housing to individuals with criminal records. Under public benefits, at the time of the briefing, West Virginia was one of 3 states denying SNAP benefits to drug felons and individuals with felony convictions. And individuals with felony convictions could not obtain SNAP or TANF benefits. Women are disproportionately affected. 32% of working-age West Virginians qualify as disabled. While incarcerated, supplemental security income and Social Security disability insurance benefits are suspended or discontinued. Once released, SSDI benefits are reinstated. Those who receive SSI go through a long process to have eligibility redetermined. We recommended that the West Virginia legislature should remove any restrictions related to the severity or nature of the crime from eligibility for public assistance benefits, including denying benefits based on offenses that are violent, sexual, or drug-related. Earlier this year, West Virginia House Bill 2459 was enacted. It no longer denies supplemental nutritional assistance program benefits to people with drug felony convictions. We also had some other recommendations. With regard to the pre-conviction notice of collateral consequences, the committee recommends the creation of a standardized model of communications between defense attorneys and criminal defendants with regard to the collateral consequences of criminal convictions, including misdemeanor convictions, which is required to be presented before a defendant accepts a plea bargain so that the defendant understands the full implication of the conviction. And with regards to the lack of general data, the committee recommends that the West Virginia Department of Military Affairs and Public Safety establish an entity with a department charged with collecting data at every stage of the criminal justice process, from arrest through reentry. Such information should be made available online and for the general public, with individual identifying information redacted after release from incarceration. Finally, Various policy groups and many of the state legislators were aware of the committee's review of these issues. Our committee is unified as a strong supporter of better legislation regarding the impact of collateral consequences. As noted in our report, the state legislature enacted a number of laws. It is my hope that this report will be shared with stakeholders in West Virginia and elsewhere. Thank you for the opportunity, and I am welcome to ask any questions.
Thanks very much, Chair Eunice. I'll open for questions from fellow commissioners, including on the phone.
Madam Chair, here.
Go ahead, Commissioner Cladney.
I'd like to thank the committee from West Virginia. I was fortunate enough to be able to attend that briefing, and I was quite impressed with the slate of witnesses and very impressed with the knowledge and inquiry of the committee itself on the subject. I was especially impressed with the witnesses that they were able to obtain who had experienced collateral consequences. The importance they placed on the subject was very impressive. I'd like to thank our CQ report. I find excellent. The committee's work complements our commission's work on subject and adds to the discussion. I'd like to ask if the committee has any plans. And I love the idea of establishing a pro bono legal services for housing and other issues that arise from the imposition of collateral consequences on people. Does the committee have any plans of transmitting this or having discussions with the West Virginia Bar on that subject?
If you could turn your microphone back on. She's coming. Thanks.
Excuse me. I'm not aware that our committee was speaking to anybody on a formal level, but there are people on our committee who are very connected to the bar in West Virginia. So there might be some informal conversations going on, but that was not at this time planned.
I noted in your report that you have a formal recommendation to the State
Yes,
Bar,
yes.
and I hope that you'll be able to at least to transmit the report, including that recommendation to the State Bar. I too was really struck by that recommendation and thought it was a terrific idea that the State Bar include a program that would help with reentry, and there are parallel State Bar programs that have been extraordinarily effective outside this area, and so the comprehensiveness of the recommendation seemed especially important. So I do hope that the committee will choose to send the report to the State Bar so they might think about whether they can take up the recommendation. And Commissioner Cladney, if, just with your permission, you were breaking up a little bit as you were speaking, and I just want to make sure the record is clear. I think you were complimenting the Regional Programs Unit also for supporting the committee in this report, and so I just want to make sure that the Regional Programs Unit hears that and knows that was your commendation. Go ahead, Commissioner Cladney.
Them and Ms. Davis for the report, yes. I'd also like to add that I thought that the idea of notice to the defendant is very important. I believe we had that in our report. And the canvass that is currently done by courts really isn't sufficient to give defendants an idea of what they're stepping into. And I'd like to compliment the committee on that recommendation as well. Thank you. And thank you for your presentation today. I thought it was excellent.
Madam Vice Chair.
I, too, would like to thank the committee for looking into this topic, and thank you for being with us. I was wondering, I'm quite interested in the housing issue, and I've read your recommendations in connection with that and the targeted funding and the public benefits. It's my understanding that it takes roughly $2,000 to $3,000 for an individual to set up a household themselves. I was wondering whether there was any discussion about what kinds of compensation is provided to inmates while incarcerated, and whether there might be an increase in whatever money's paid, and thereby increasing the likelihood that upon release, these returning citizens would have access to a pool of money that specifically would be used to help set them up in a household? Was there any, my question is, was there any discussion or what information would you have that would bear on a notion like that?
I'm not aware of that discussion. If I am misspeaking for the committee, I can certainly try to find that information for you. But it is a good question, and I certainly can take that back to our group and try to answer it for you later. So, apologize.
Oh, please do not apologize. Thank you, Madam.
Chair Eunice, I think that your testimony today is especially timely, given the Trump administration's recent decision to limit access to SNAP food assistance benefits, and the material in the committee's report about the importance of SNAP food assistance benefits to returning citizens was extraordinarily compelling, thorough, and I thought timely in light of the national conversation about this as well. I congratulate you and the committee on working to change state law and the success in seeing state law changed on that topic for West Virginia. And so in this time when I think nationally hundreds of thousands fewer people will be able to access these critical benefits, I'm glad to know that in West Virginia there will be some improvement, and I congratulate the committee on helping to make that happen. So thank you for that. I also thought that the report in general was extraordinarily thorough, extremely well written, very compelling, and the inclusion of information from people whose life experience leads them to know the challenge of the collateral consequences on reentry was really terrific. So thank you very much for giving us such a comprehensive window into the experiences in your state and for the careful examination of this really important issue. Thank you. Commissioner Ardegui?
Just briefly, two comments. I wanted to thank you for the focus on the issue and the wonderful effort that went into the report. It's a really first-rate effort, and I think it's an exemplar of some of the work that we've seen from our state advisory committees, who we describe as the eyes and ears of the commission throughout the nation, but so many of these committees have done extraordinary work on issues on which you identify and set the agenda and determine what is important in your own state, and to lift it up, to gather the information, to bring the experts together, and to create change in a public forum because of the work you do is in many ways precisely the design of your committees. And so please share with your fellow committee members that we appreciate the effort, that in the face of a national discussion about criminal justice reform, we need to think not only what's happening with people on the way in, but what the consequences are in the country of what our practices have been for a long time. And it seems to me that as a matter of public policy and rationality, having people have an opportunity to make productive use of their lives once their time has been served and paid is an essential element of a thriving democracy, as opposed to relegating people to dead ends in life and opportunity. And so hats off to you, and please share our compliments with your colleagues.
So with that, I will thank you very much for coming here. I hope that you will stay and allow us to take a picture with you afterwards and share proof that you were with us. And also just very many thanks before you get up to you for your service and for your leadership on the advisory committee, and to the committee as a whole for being so extraordinarily active. It's really a pleasure to get to benefit from the expertise and the work of the committee. So many, many thanks, and I hope you will take that back to the committee as a whole as well. Thank you.
Thank you very much.
Next, we will hear from our Alaska Advisory Committee's Chair, Natalie Landreth, on the committee's recent report on Alaska Native voting rights. And I will note that I think it is too early even to call it early morning in Alaska right now. So many thanks to you for getting up at this brutal time, and we look forward to your presentation. Go ahead, Chair Landreth.
Thank you very much. Yes, I am not usually up at this time unless I'm still up from the night before. So bear with me and be merciful with questions. So I'm going to present an overview of our report entitled Alaska Native Voting Rights. There were two pieces of this report. One was to evaluate the effectiveness of the implementation of the Toyakak versus Mallott settlement and court order This was a Section 203 case that contained a broad variety of remedies ordered by the federal court. And the second piece of the report is the potential disparate impact of a statewide vote-by-mail system that Alaska, at the time of the preparation of the report, was indeed considering. But if I may offer this guess, it appears that the close scrutiny to this issue by the State Advisory Commission and others during the pendency of that process caused the state to reconsider, and it will not be implementing a vote-by-mail system at this time. We have maintained all of the information and recommendations in this report because that issue could, of course, rear its head at any time. I know you do have the report, so I'm going to focus very basically on really key findings and recommendations from the report. There are, by way of very little background, because again, that is pretty well detailed in the report, there are 14 different census areas in Alaska covered by Section 203 of the Voting Rights Act. And there were two successive cases lasting almost 10 years of litigation to enforce compliance in only four of those census areas. And the purpose of this report, prior to my arrival, the committee had chosen to evaluate and implementation with those court orders. So that is the origin of the mandate here. Some of the key findings are that the state, despite making improved efforts under certain administrations, the state was still not in compliance with the court order. 46% of the poll workers received no training prior to the election within the past year, and 40% overall had never received training. The second key finding is that bilingual poll workers were not trained on how to translate the contents of the ballot. This was a key feature in the lawsuit and a surprising discovery during the preparation of this report. The Division of Elections in finding number 3 was very candid and admit they were unable to adequately log the frequency and effectiveness of any of their outreach. This also was a key feature of the court order because the case showed that in terms of outreach, the average voter would receive an entire official election pamphlet in English that contained more than 100 pages of information, and yet in advance of an election, most Native villages were receiving 3 pieces of information: date of the election, time of the election, and notice that there would be an election along with the place where you could vote. And that was the discrepancy. And so the lack of outreach in the third finding was a real surprise, as that was the core of the case. I'm sorry, I should say the lack of the ability to document or log the outreach that was supposed to have been occurring. The fourth finding was that some villages just didn't have the bilingual poll workers available that were required by the order. And the fifth finding, the Division of Elections admitted that it had not been able to complete all of the translations. We did discover in number 6 that even for materials that were translated, there were no translated materials in 1/3 of the covered villages, representing some pretty significant discrepancies between what was ordered and what is actually occurring. I will leave the balance of the findings on that order, as I know the Commission has them, but those were the key features. Were and are, is the state of Alaska complying with the requirements of the Toyakak versus Moloch court order? Not according to this information, no. And I should add that this information is not derived from an independently commissioned State Advisory Committee study. This is all derived from witness testimony and primarily from federal observer reports that have been entered into the record in support of this committee's report. The second component were findings concerning the potential impact of a vote-by-mail system. This came up at the time that we were beginning the legwork on the Section 203 piece of the report. And so we thought it critical because we pointed out the overlap between trying to implement a vote-by-mail system on a non-English speaking population that was under a current court order requiring extra assistance. So I will discuss the primary findings of this piece as well, and then at the end discuss the recommendations that we are requesting the Parent Commission make. The first was that voters across the board in testimony expressed grave concern over Alaska's potential implementation of a vote-by-mail system based on the notoriously slow mail system that can take 2 to 3 weeks just from Anchorage into the villages. The weather and the fact that the many of the airports in rural Alaska do not have they basically have dirt or gravel runways means that you are limited in access, and so reliance on that struck people at the outset as unwise. The second finding is that there had been no comprehensive study about what the impact would be on Alaskan natives, specifically on people who are limited English proficient or linguistically isolated. The third finding is that there were specific concerns raised about the use of a vote-by-mail system, and one of these is that this is a nationwide issue in Indian country, but specifically in Alaska. There are a number of families that can often share P.O. boxes, which means if your ballot is mailed to you, the chance that you are going to receive it is much smaller than someone who has their own P.O. box. It's what one academic has referred to as the leaky pipeline. There are lots of places in which your mail disappears, especially in this kind of a scenario. The fourth was that the implementation of a mail-in voting system, just in terms of its as a bare proposal, didn't make any sense because the agreement, the court order in the Toyacat case, required language assistance, a lot of it in person, and it could not be complied with in a vote-by-mail system, meaning that the implementation of that kind of system on these communities would de facto be a violation. And the fifth one is that in-person assistance is required by a lot of other laws as well as the court order in this case, and you simply can't do that in a vote-by-mail system unless you are going to replicate that assistance by creation of what are called voting centers. This was one of the expert recommendations for these types of communities. Finally, with regard to vote by mail, there were a number of findings specific to the Postal Service, and one which was unusual, which is the
Chair Landreth, we thank you for presenting, and I'm going to just move us on to questions from commissioners at this point. Thank you very much. I'll open for questions. Commissioner Dagdaway.
Good morning, Chair Landreth. Thank you for getting up early and for the wonderful work of this SAC in Alaska. Like Commissioner Kaladny before me, I had the opportunity to attend the briefing in Anchorage and to observe and hear the powerful testimony and the work that the SAC did to underscore the challenges that are still faced after that very complex and substantial litigation is a real value add for the people of Alaska, for which I commend you. Hearing about the case made it very clear to me that you're a better lawyer than I am. You're a better lawyer than me for sure, but the people of Alaska are lucky to have you. I was wondering if you could help explain so that people can fully understand, and you've begun to do it, but I think that there is thinking that generally vote by mail is a way to expand the franchise and try and make it easier to lower bars to voting as opposed to imposing new barriers to voting. And I was wondering if you could just animate for us in a little bit greater detail what the specific challenges are in Alaska, which was so compelling during the testimony, so that people can understand that very often one-size-fits-all responses don't work because of the complexities and the specifics of people in different jurisdictions.
Well, thank you for raising that issue. It was sort of a nationwide movement that has created the impression, or the talking points, I should say, supporting expansion of vote by mail are that it's cheaper, number one, and number two, that it expands the franchise. I can't speak to number one, especially if you're going to provide return postage. We didn't study that issue. The second is that we found there was, in looking at other states, Indian communities in other states, because we did bring experts in to say, we don't have a study on Alaska, as I mentioned in our second finding. What was the impact in Nevada or Arizona or other places where this occurred? And the fact is that these experts said to us there is no evidence that it increases voter turnout, and there are places where, if the right conditions are present, it actually decreases it. It is not a panacea for increasing voter turnout in certain areas, and the reasons are quite specific. Number one is that you must have reliable, regular mail delivery, and Alaska does not have that. We have not only the weather issue and the access issue of basically people having gravel runways, but election mail, frankly, on these small planes takes lower priority after passengers and baggage and things like that. And so that creates a third impediment. And you have others as well, one of which is the lack of availability of postal workers in all of the villages. Because of the small population, it's often hard to get them staffed at regular hours. So that creates another issue. The fifth issue is that you can't control when something is postmarked. You put it in the mail on Election Day, for example. You and I will put it in a mailbox where there is collection that day. It will get postmarked that day. That ballot will be counted. That does not exist in the villages. If there is no one physically at the post office for you to hand it to and watch them stamp it, it will not be stamped until it arrives in Anchorage 3 to 5 days later, which means that all of these ballots will de facto be presumed late. This is something that was brought up during the testimony. But I should add, one of the issues that in Alaska creates vote by mail problems that is nationwide, really, because Alaska does have its unique issues, but the nationwide problem is this. There isn't really a standardized addressing system on reservations. They aren't platted in the same way where everybody will have street addresses. There is a significant number of non-traditional addresses, such as house on BIA Road 7 behind the grocery store. That will be a real address on certain reservations, and as such, they cannot get delivery of certain things because there is no standardized process for which that occurs. We are currently working on that issue separately at Native American Rights Fund, but that is one of the primary reasons that we encounter difficulties looking at this issue.
Thank you. Two more questions, just briefly. One is I want to know if there were any specific findings that we should be aware of that you want to underscore for us, and then separately, what is the Department of Justice doing to enforce the protections for Native Alaskan voters in a very large state where substantial resources are necessary to make sure that people have access to the vote?
So that's our very first request and recommendation to the Maine Commission is to send this report and a formal request to the Department of Justice to vigorously enforce Section 203 of the Voting Rights Act in Alaska. There's an enormous number of covered jurisdictions, covered populations, and yet the only people to enforce Section 203 is myself at the Native American Rights Fund with the assistance of the state affiliate of the ACLU during our first lawsuit. And it's simply like trying to empty the ocean with a teacup, that it has to be monitored. As part of that component, our recommendation and request to the Maine Commission was also that it issue this report with a recommendation directly to our own Division of Elections and to the Department of Justice that this court order be extended based on the fact that we do not yet see even close to full compliance with that order. And my apologies, your first question was about which finding to highlight, and my question is what topic are you referring to? Do you mean with regard to 203 or do you mean with regard to vote by mail?
Well, maybe the way to come at it is helping people understand what the challenge is in the 203 context with respect to the number and nature of Native Alaskan languages. I was struck and learned something about how many different languages there are, how not all of them are written, and the specific complexities of trying to provide access to eligible voters, and how important 203 is, which of course was what I understood to be at the core of the litigation.
Right, so there are a huge variety of Alaskan Native languages, and due to a previous discriminatory policy of the lack of accessible schooling, the byproduct is that a lot of people still speak Alaskan Native languages. It's extremely common. There are, in fact, 8 different census areas in Alaska for which Yupik is a covered language. However, there are at least 8 different dialects of it, and it poses an enormous challenge for someone like a private organization, a nonprofit, to litigate protection for that. There are also different languages in the interior known as Gwich'in and other Athabaskan languages. And then up on the North Slope, not touched on this report, but a covered language that has received very little attention, is Inupiaq. And that is the people further up north in Alaska. So nearly the entire state is covered for these. And of course, pre-Shelby, we did have de facto statewide coverage under that coverage formula, but even the census level jurisdictions still have coverage. And it is really a challenge to do that as a private organization. So one of our key requests is to the Department of Justice to vigorously enforce this, and very importantly, related to that, is to continue to send federal observers to Alaska. That was the primary source of information about specific failures at the polling place that we were able to rely on without having to use individual witness testimony. That supplemented what we learned. But that was another key recommendation, was to continue to send federal observers. As a source of information, they are second to none.
Thank you.
Thank you, Chair Landreth. I'll open for other questions, including on the phone. And I'll just note for myself how much I appreciate that your advisory committee did both the quick, brief memo that summarized the information from the investigation so that we had it in time for inclusion in our voting rights report, and then that the committee returned to this fuller explanation and discussion of the issues that you investigated, so that we have that and Alaska has that for a full and complete record. I have used the information from both materials many times in our presentations about voting rights, and I was very, very grateful to be able to incorporate the Alaska-specific information in the report that we issued on voting rights, which I thought was incredibly helpful. So I send you my thanks for both documents, and also my congratulations for achieving a victory along the way in the course of the investigation to protect voters in Alaska from what I take the committee to believe harmful vote by mail process that was under consideration. So with that, I thank you for your early morning presentation to us in addition to the work, and for your leadership and service on the advisory committee. And thank you very much. I hope you will take our appreciation back to the rest of the committee. And with that,
Thank you very much.
I will turn to the next item on our agenda, which is a discussion and vote on the Commission's report titled Federal Me Too, Examining Sexual Harassment in Government Workplaces. We'll hold 2 votes. First, we'll consider the report, and second, we will consider findings and recommendations. To open the floor for discussion, is there a motion?
So moved.
I'm hoping that you're going to move to approve the report as circulated by in the last few days.
Because I'm feeling such sympathy with Chair Landreth. I'm feeling that it's 6 o'clock in the morning, so I need a little additional prompting. I am indeed going to move approval of our federal Me Too sexual harassment report examining sexual harassment in the federal workplace.
And as circulated in the last few days with a set of red lines and corrections, is that correct?
As circulated December 4th by my special assistant, the inimitable Irina Vidolovich.
Thank you. Is there a second?
Second.
So I'll offer a few points to begin our discussion. First, I thank Commissioner Adegbile, who's not listening, for his leadership on this project. And I thank our staff who are listening, particularly Catherine Colleton-Gonzalez and Merrick Xavier Breyer, as well as other members of our staff who pitched in to research and develop this project. Thanks to their efforts, we today consider a report that looks at federal workplaces to assess how well this sector addresses workplace sexual harassment. We looked at the practices of the Equal Employment Opportunity Commission and their enforcement efforts to combat workplace sexual harassment, and we examined practices at two federal agencies, the Department of State and the National Aeronautics and Space Administration, commonly referred to as NASA. At our briefing, we heard compelling testimony from a member of Congress, current and former federal officials from EEOC, state, and NASA, legal and academic experts, as well as individuals who shared their own experiences from federal workplaces. I believe this report honors that testimony, and I look forward to seeing the reforms that its text can drive. I now open the floor for discussion, beginning with Commissioner Adegbile as the sponsor of this project.
Thank you, Madam Chair, and I too begin with thanks for the efforts of the U.S. Civil Rights Commission and its able staff that put in a Herculean effort to turn this report in short order. In particular, I would like to thank Merrick Xavier Breyer for his wonderful work in leading the effort for OCRE, and of course the director of OCRE, Catherine Colleton-Gonzalez, for stewarding the effort as well. Because it's a labor of love, and because we have legal requirements in our reports, our General Counsel's Office, Maureen Rudolph and Pilar McLaughlin, also made substantial contributions in the review, as well as our special assistants. I've already mentioned that Irena Vidolovich made extraordinary contributions, and on this report we had really a set of committed interns that made special contributions, Corey Pruitt and Ryan Kelly, who deserve special mention. As always, I thank the entire staff who contributed to the report, and I thank my commissioners whose inputs and eagle eyes have helped to make the report stronger as we move forward. And so with those thanks, I just wanted to say a quick word about why we have focused on this topic, what we focused on, and at the risk of putting the cart before the horse, foreshadowing some of what we may have learned if our votes go in the way that I hope they will today. So why we focused on this issue, sexual harassment in America and in the American workplace is a substantial problem. It's a problem that we've come to understand a bit more about in recent years as the Me Too movement has shone a Klieg light on a problem that too often was existing outside the purview of people that should have their eyes on it and a responsibility to stop it and address it. The federal government is not immune as an employer from these problems, and indeed has a special obligation in some sense in that the federal government is the largest employer in the United States. Approximately 2 million employees are federal government employees. And so if this is a problem that we have observed in America, we must certainly ensure that the federal government, as having the leading responsibility for enforcing civil rights, is making sure that we have best practices in the federal workplace. And we also looked at this issue because like other areas, there are so many agencies of different types that there's lots of complexity in figuring out how this problem may manifest in the remote places where people work. What we examined very quickly, and we've already heard this from the chair, a comprehensive review of a workforce that's that big, of a government that's that big, is difficult. And so we've not been able to look under every rock or every corner, but we have made a concerted effort to try and look at this issue in the federal government because we've learned that it's been under-examined in the federal workplace. More and more attention is coming to this issue nationally and in lots of different workplaces, but we thought that it was time that there be an additional focus on these issues in the federal workplace, and so we did indeed look both at the EEOC's important role for enforcing protections in this area, for advising about policy and best practices, and that we hope will make some contributions. But we also took a deep dive into two of the larger agencies, and those agencies were picked, as we will describe in the report, for some reasons, to have an example of very large governmental agencies to see how they're handling the issue and addressing the issue, and we compare and contrast their approaches. We looked at the applicable law to talk about how it is playing out in practical terms, and we held a briefing where we heard from victims of sexual harassment, lawyers, administrators, and experts of all kinds that really added layers to our understanding. We also held public comment and had a public comment portal available on our website so we could add to the dimension of it. And all of these things have contributed to our study as well as the data that we looked at. And so again, and before we turn to the vote, very quickly, what we learned disclosing that this is a bit of a cart before the horse approach. So I'll keep it very high level. We learned that sexual harassment is driven by power dynamics principally, and that it tends to infect certain types of environments, such as isolated workplaces, but those are not the only places that it exists. But there are certain conditions that may increase the likelihood of sexual harassment risks in the workplace. We learned also that the problem is dramatically underreported for a variety of reasons. So while we point to data and talk about existing data and a number of different studies in the report, one of the things that the studies have in common is this phenomenon of people not reporting when sexual harassment is visited upon them. And that happens for a number of different reasons, including perceptions of the adequacy of the remedial measures that are in place, and also fear of the consequences and retaliation and career impacts for those who have experienced it. And finally, we learned that sexual harassment has both individual and workplace-wide impacts. It has individual impacts on the individuals that have this limit and impede their own work aspiration and experiences. It has economic impacts, which are both going to the individual and also have a larger societal consequence for agencies that have to deal with replacing people or not getting the most out of people that are being inhibited by the way that they're being treated in the workplace. And so I was struck by the testimony. I learned a great deal from the study, and I look forward to the vote and the comments and input of my commissioners as we have a further discussion.
Thank you, Commissioner Degbolet. Any further discussion on this report? Hearing none, I'll call the question. We can take a roll call vote. Commissioner Degbolet, how do you vote?
Aye.
Commissioner Harriet?
I vote no.
Commissioner Kursanow?
No.
Commissioner Cladney?
Yes.
Commissioner Yaki?
Aye.
Vice Chair Timmons Goodson?
Yes.
And I vote yes, the motion passes. 2 commissioners opposed, no commissioner abstained. All others were in favor. Next, we will consider the findings and recommendations for the report. To open the floor for discussion, is there a motion?
I move consideration of the findings and recs without further commentary.
And I hope by consideration you mean a vote to approve the findings and recommendations as circulated by your special assistant on December 4th with a set of edits.
I do, and I would like to note for the record that sitting behind me is my special assistant, who is wondering again why I won't read the script that's in front of me so that I can adequately discharge my duties. But as we sometimes say, it takes a village, and I'm glad to be a member of this particular village.
And to be clear, we all wonder that. But is there a second for Commissioner Degbolet's excellent motion?
Second.
Thank you. Any discussion or amendments? Hearing none, I'll call the question, take a roll call vote. Commissioner Degbolet, how do you vote?
Aye, with the substantial input of Irena Vandolovich.
Commissioner Harriet?
I almost wanted to second that one myself. But I'm going to have to vote no on the substance.
Commissioner Kursanow?
No.
Commissioner Gladney?
Yes.
Commissioner Yaki?
I'm still getting used to the fact that Commissioner Narasaki's name isn't called before mine. Aye.
It's painful in her absence, but thank you. And Vice Chair Timmons Goodson?
Yes.
And I vote yes. The motion passes. 2 commissioners opposed, no commissioner abstained, all others were in favor. I note now, with the adoption of the report and findings and recommendations, the clock begins ticking with respect to deadlines for statements and rebuttals. Statements will be due on Monday, January 6, 2020, with rebuttals due on February 6, 2020. Commissioners must file notice of their intention to file a surrebuttal by February 13, 2020, and then must file the text of their surrebuttal on February 20, 2020. The next item on our agenda is a discussion and vote on the fiscal year 2020 briefing dates. To open the floor for discussion, I move that the Commission schedule briefings for Friday, March 21st on the approved project on maternal mortality and for Friday, May 8th on the approved project on bail reform. Is there a second?
I second.
Thank you. Any discussion? Hearing none, I'll call the question, take a roll call vote. Commissioner Degbole, how do you vote?
Aye, with the substantial input of Irena Vidolovich.
Commissioner Harriet, how do you vote?
I vote yes.
Commissioner Kirsnow?
Abstain.
Commissioner Gladney?
Yes.
Commissioner Yaki? Commissioner Yaki?
Sorry, I could not hit the mute button in the correct manner. My vote, I cast, is an aye.
Thank you. Vice Chair Timmons Goodson?
While I'll not be here with you, I cast an enthusiastic aye.
Thank you. And I vote yes. The motion passes. No commissioner opposed, 1 commissioner abstained. All others were in favor. We now turn to our next amended agenda item, which is a discussion and vote on a statement regarding the Commission's legislative and oversight priorities for Congress in 2020, as circulated last week. I will say that I offered an error. I'm being corrected. The date for the project on approved project on bail reform would be Friday, May 20. So I think we need to retake that vote because I said the wrong day. So I apologize to all.
I would like to offer the services of Irena Vidolovich to the chair.
Oh, okay. Sorry. I'm wrong yet again. It's Friday, March 20, that would be the date for maternal mortality, which is to say that not only do we need Irena's help, but we also need Ruku's and Kathy's help. Thank you all for the village today. So if we could vote again. First, is there a second for my corrected date?
Yes, I second.
Thank you. And then, Commissioner Degbole, how do you vote?
An enthusiastic aye, all by myself.
Thank you. Commissioner Harriet?
I vote yes.
Commissioner Kirsnow?
Abstain.
Commissioner Gladney?
Yes.
Commissioner Yaki?
Oh, sorry. I still think I have 3 seconds before I get called because of Commissioner Narasaki. Aye.
Thank you. Vice Chair Timmons Goodson?
Yes.
And I vote yes. This motion passes with the correct date. No commissioner opposed, 1 commissioner abstained. All others were in favor. So now we will turn to our next amended agenda item, which is a discussion and vote on a statement regarding the Commission's legislative and oversight priorities for Congress in 2020, as circulated earlier this week. To open the floor for discussion, I move for approval of this statement. Is there a second?
Second.
Thank you. To begin discussion, I'm going to offer a few points. I'm not going to read it because it is very long. But our points are that last year in December 2018, the Commission approved a statement of legislative and oversight priorities for the 116th Congress. That statement drew on the Commission's work up to date and it drew on in-depth reports and policy statements. I'm delighted to note that in the last year, Congress has heeded our call for action in many ways, in both their oversight and legislative capacities, and there is still more work to do. And the Commission has also produced a significant amount of new research and analysis since December 2018. So I ask my fellow Commissioners to support this new statement of priorities, recognizing the work Congress had done and urging it to do more to ensure that all civil rights are protected. So any other discussion of the statement? Hearing none, I'll call the question and take a roll call vote. Commissioner Degbele, how do you vote?
Aye.
Commissioner Harriet?
I vote no. I would explain, but I think I'm the only thing standing between the Christmas caroling. So let's just go. I vote no.
Commissioner Kirsonell?
No.
Commissioner Chladni?
Yes.
Commissioner Yaki?
Aye.
Vice Chair Timmons Goodson?
Yes.
And I vote yes. The motion passes. 2 commissioners opposed, no commissioner abstained. All others were in favor. Commissioner Harriet is not the only thing standing between now and Christmas celebration. The next item on our agenda is a discussion and vote on forming a subcommittee for our ongoing project on sub-minimum wages for workers with disabilities for the purpose of conducting site visits. To begin discussion, is there a motion?
Yes, Madam Chair. Dave Chladni here. I move to authorize the Chair to appoint a subcommittee of commissioners to conduct 1 or more site visits on our sub-minimum wages project. Specific sites will be selected in consultation with OCRE and the subcommittee. Our discovery materials limit the traveling delegation for site visits to 4 commissioners. So if the subcommittee is larger than 4, the subcommittee will determine its meeting with commissioners which ones would travel to each site. Also, in the event the subcommittee is not permitted under our regulations in the future, I move to authorize the staff director to continue the site visit planning and to provide a traveling delegation of commissioners to attend and participate in site visits in accordance with our regulations. We've done some work on it. Oh, I need a second already.
Thank you, Commissioner Chladni. You were breaking up a little bit at the beginning. Just to clarify, your motion is that the chair would appoint a subcommittee and with the caveats that you then followed. Is that correct?
Yes, and
Thank you.
if one can't be conducted, did you catch that part of the motion?
Thank you. Is there a second?
Yeah.
Second.
Thank you. Commissioner Chladni is the sponsor of this motion. Would you like to begin our discussion?
Yes, as you know, we had a briefing that was quite extensive. I think it's worthwhile for the commissioners to actually go and see the 2 different types of situations. One is the work centers as they are now, a functioning work center, I should say, and we should also go and see what a competitive integrated employment is like as well. I think that's that's what the purpose of the subcommittee would be. Although my special assistant, Amy Royce, says I made a mistake somewhere along the line. And I'm not exactly sure what she's talking about. So perhaps...
We'll just maybe pause there. And
yes.
I'll continue the discussion with a few points, and Commissioner Chladni, I'll give you a chance to join in again if you like. So first, I just appreciate Commissioner Chladni's leadership in promoting site visits for this investigation, allowing us again to gather information outside of the comprehensive briefings that we hold in D.C. I have found it immensely valuable when the Commission has traveled outside of D.C. in the past, and I look forward to seeing what information and insight can be gained from these site visits that can be incorporated into our ultimate report, findings, and recommendations. Commissioner Chladni, it sounds like you have more you'd like to add?
Yes, I would like to reread my motion if I could. I'm obviously, it's early here, although not as early as it was when we started. I move to authorize the chair to appoint a subcommittee of commissioners to plan and conduct 1 or more site visits for our sub-minimum wages project. Specific sites will be selected in consultation between OCRE and the subcommittee. Our discovery materials limit the traveling delegation to site visits of 4 commissioners. So if the subcommittee is larger than 4, the subcommittee will determine in its meetings which commissioners would travel to each site. Planning will take place with input from the commission staff. In the event the subcommittee is not permitted under our statute in the future, I move to authorize the staff director to establish a site visit planning committee, which will include input of the staff, special assistants, and commissioners to continue site visit planning and to provide for a traveling delegation of commissioners to attend and participate in site visits in accordance with our regulations. If I could get a second for that or amend my motion to that, I would appreciate it.
Thank you for the amended motion.
And I apologize.
Is there a second?
Second.
Thank you. Unless there's further discussion, I'll call the question, take a roll call vote. Commissioner Degbolet, how do you vote?
Aye.
Commissioner Harriet?
Yes.
Commissioner Kirsenow?
Yes.
Commissioner Gladney?
With the great assistance of my special assistant, Amy Royce, I vote yes.
Commissioner Yaki?
I'm thinking. Would you keep on going?
Vice Chair Timmons Goodson?
Yes.
And I vote yes. Commissioner Yaki, we return to you for your vote.
Yeah, I mean, I'm going to vote for it. I'm a little disappointed over the fact that similar discretion was not granted to the subcommittee I chaired on immigration detention. I thought it would have added greatly to the discussion we had yesterday before the Congressional Hispanic Caucus. I note that some of the comments raised regarding resources and the ability to do that have been not raised with regard to this, but I will vote yes.
The motion passes. No commissioner opposed. The motion passed unanimously. No commissioner opposed and no commissioner abstained. Commissioner Yaki, for what it's worth, for our record, we are in a different year from the subcommittee that you chaired, and then living with different fiscal and staffing constraints than we lived with at that time. But I hear you and share the view that that investigation and all investigations that we conduct would benefit from site visits outside DC.
Well, I would just like to add that, I have always been one of the biggest proponents for being able to get out of the Beltway. I actually believe that it's better for the entire commission to go and do a site hearing, and I'd rather have our resources prioritized in that manner. And I'm thinking especially with regard to the report to the report regarding the response to hurricanes as a perfect example of that. And I would hope that when we are deciding to allocate where and when to go for this or any other site visit, that we are cognizant of the fact that I believe a higher priority is to get the entire commission out of DC, and with regard to the coming fiscal year, especially with regard to the report regarding the hurricane and its disparate impact on the people of Puerto Rico, for example. So I just want to put that out there for the record. I would like that to be addressed at some point by the staff director, and it is, and if we need to, for example, reserve funds for things in the future that are extraordinary and that do come up, so that we are not faced with a situation as I was faced last year. That would be, I think, smart and prudent planning.
So there are statutory constraints on the reservation of funds. We have to spend the funds appropriated for the commission in a given year. But your comments are timely. I think we can move next to the monthly staff director's report. And I note that our record is that we have voted for the disaster investigation that we would travel.
Madam Chair, could I bring up something here. I think we need to prepare for the contingency, even though it's not a really big one, that we're not going to be able to have a quorum for the briefings that we just scheduled a minute ago. And I would like to make a motion that in the event that there is not a possible quorum, that there be a subcommittee to hold those briefings so that the show will go on, even if the Trump administration and the members of Congress who right now are supposed to be appointing members, even if they don't do that in time, because as you might recall, our own vice chair didn't make it onto the commission until several months after there was, and Commissioner Narasaki as well. So can I make a motion to that effect?
Sure.
I move that in the event that a quorum is not available for the commission for the two briefings that we scheduled earlier today, that a subcommittee consisting of those members who can make it be able to hold that briefing. I say that without saying that it is impossible for the commission to hold a briefing without a quorum. That's a question of law that we don't need to address. But if that issue should be resolved against us, then a subcommittee consisting of any commissioner who can make it be able to hold those two briefings.
I have a question.
First, I do think we have a motion, so let me just second it, so then we can have a discussion of the motion, and then go ahead, Madam Vice Chair.
Have we done this before, and what would be the effect of such a hearing by the subcommittee and the product that comes from it?
I think that what has happened before, now don't quote me on this because I may be misremembering. There was a briefing that took place before a less than a quorum of the commission at some point, maybe even in Kansas City. I mean, this is before I was on the commission, and there was some dispute as to whether or not a quorum is necessary to hold a briefing, or whether it's fine to have it with less than a quorum because they don't act. There's no actual business transacted. They just listen and ask questions. There are no motions in that. So I think that the only thing this would do would be allow the commissioners to conduct the briefing, allow them to ask questions. It would nevertheless be a commission report at which all commissioners would be able to vote up or down on eventually. It's just for the purpose of holding the testimony so that we don't have a weird situation where we don't get 5 commissioners because perhaps 3 appointees haven't been made and 1 commissioner has the flu. We don't have to tell the witnesses, go home. We can hold it anyway.
For what it's worth, I believe that it would be as if those of us who were not there for briefings in the past were still voting on ultimate reports that follow from it. So I think that there's logic to that, and I had a chance to confer with the General Counsel after you raised your motion, and it is the position of the General Counsel that as considering it in this moment, we would be able to move, but I think it's appropriate. We would be able to hold the briefings, but let's have the vote just in case, so that we're safe. And I appreciate the forethought. Thank you. I'm sorry, Madam Vice Chair. Did you have?
This is Commissioner Yaki. I was involved in some of those briefings that Commissioner Harriet discussed. I think actually the briefing she may be referring to was the one that occurred in Omaha. I think in 2007 or 2008. Throughout my tenure, it has always been the position, both of the Office of General Counsel and the staff director, that briefings, because there is no action taken other than the hearing and taking the testimony, do not require a quorum. And in fact, there have been many instances when during the briefing, commissioners might wander out, somebody may come up, and the briefing was allowed to continue despite the fact that there was not a quorum up on the dais. So if I believe that has been the continuing interpretation and still continues to be the continuing interpretation going forward. Again, the caveat is that you cannot take a vote, you cannot take any action, but you can hear and receive testimony and ask questions through the briefing process absent the quorum.
Thank you. So, go ahead, Commissioner Harriet.
Yeah, I like that logic. I hope that's right. I just want to do this as a precaution.
I think that's right, and we have a motion, and it is second. So let's go through our vote. Commissioner Degblay, how do you vote?
Aye.
Commissioner Harriet?
Yes.
Commissioner Kirsnow?
Yes.
Commissioner Chladny?
Yes.
Commissioner Yaki? Commissioner Yaki?
Sorry, I hit the mute button again. I'm going to abstain.
Vice Chair Timmons Goodson?
Yes.
And I vote yes. The motion passes. No commissioner opposed, one commissioner abstained. All others were in favor. So with that, we can turn to the staff director for the monthly staff director's report.
Thank you, Madam Chair. In the interest of time, I will not go over what is already contained in the report. I'm always available to speak anytime with the commissioner about information contained in the report. So I thank you. I would like to just make one more comment, Madam Chair, that this is the last meeting in 2019. I want to thank all the staff for the amazing work that was done this year, commissioners and special assistants included. As you know, we started off this year delayed by the shutdown of the government. Nevertheless, staff came together, worked together as a team to overcome a lot of challenges, and with that, we've released an extraordinary number of reports, briefings, the regional programs, state advisory committees' work has been phenomenal, and just everywhere, up and down, every department within our agency has been phenomenal, and I can't thank the commissioners enough for their support and their work and the hard work they've done, and the hard work the special assistants have also done in helping the staff achieve these goals. So with that, I just want to thank everybody and wish them well in the coming year, 2020.
Thank you, and I wholeheartedly echo the thanks and the gratitude for how productive the Commission has been and how collegial the Commission has been in what was a very difficult year with the longest shutdown in the history of the federal government and extraordinary work output volume. So thank you to all for meeting and exceeding those expectations. That includes the business on the agenda for today's business meeting, but before we adjourn, I would like to take a moment to recognize Vice Chair Timmons Goodson, whose term with the Commission ends today. Before Vice Chair Timmons Goodson came to the Commission, she was an Associate Justice on the Supreme Court of North Carolina and served for many years before that on the benches of the North Carolina Court of Appeals and the 12th Judicial District of North Carolina. Her years of judicial service to the people of North Carolina have been recognized with awards such as the Order of the Longleaf Pine, Liberty Bell, Appellate Judge of the Year, 3 honorary degrees, and induction into the North Carolina Women's Hall of Fame. Vice Chair Timmons Goodson began her career as a district manager of the United States Census Bureau in the Department of Commerce from 1979 to 1980. And her professional quest for justice began as an assistant prosecutor and continued as a legal services lawyer in Fayetteville, North Carolina. These professional accolades and accomplishments, as impressive as they are, only hint at the gift whom the Vice Chair is. Madam Vice Chair, I have been grateful for your wisdom, insight, and steadfast support as the Vice Chair of the Commission. You have served with honor and dedication. And in my nearly 3 years overlapping with your term, you have been a constant promoter of more equal justice, a calm voice of wisdom, a phenomenal colleague, and best of all for me, my friend. I will sorely miss you. Vice Chair Timmons Goodson, thank you for your service to the Commission and to the country. I'm going to just pause in case other commissioners want to step in. This
is Commissioner Yaki here. I just would like to say, I want to echo everything that you said, Madam Chair, and just say that on a deep personal level, the utmost respect I have for Commissioner Timmons Goodson's personal story and what she has done and brought to this commission. I consider her a friend. I had a wonderful time with her yesterday before at least 9 members of Congress who came to a briefing that they asked us to attend to brief them on the immigration detention report. She, of course, did splendidly, as we would all expect her to be. But she is certainly someone who, during my long years on the commission, is someone who I believe is of the first caliber and the first rank as a commissioner, but more than that, as a human being, as a person, as someone who's a role model to so many in this country. I just want to add that and say thank you. And this is not goodbye. It's just farewell for the time being. And we look forward to working with you and seeing you in the future for your future endeavors and future successes.
Thank you, Commissioner Yaki.
Madam Chair, Dave Chladny here.
Go ahead, Commissioner Chladny.
I'd like to thank Vice Chair Timmons Goodson for her 6 years of service and commitment to civil rights. Her strong and quiet leadership and her logic and humanity have added to our work at the Commission tremendously. She treats everyone with respect and honesty, and I've learned so much from her during her time here. I'd like to thank her for her service and tell her that she'll be very, very missed from our Commission. Thank you, Vice Chair Timmons Goodson. I will miss you tremendously. Thank you.
Thank you. I know that Mr. Staff Director, you wanted to speak?
Thank you, Madam Chair. On behalf of the staff, all the entire staff, we want to thank you for your graciousness, your wisdom, your kindness to all of us. You often helped mediate some challenges that we would encounter at times, and I can't thank you enough personally. When I first arrived, you were a North Star to me and provided me with great counsel as to how to operate professionally as the staff director here. You will be missed. Your graciousness in class and how you've always conducted yourself was acknowledged and known by all of us here. So we thank you. You will be missed, but we also want you to keep engaged with us and keep an eye on us and make sure that we are carrying out our responsibilities and missions. So we wish you the best in your future endeavors, and we look forward to, again, working with you sometime into the future.
Commissioner Dagbally?
I would like to add my voice to the tributes of our colleagues today and to note that Commissioner Timmons Goodson is an extraordinary person in so many ways. And I was just scratching down some of the things that I've had the opportunity to observe and to learn from over the course of the last 3 years, and that I have benefited from personally, and that I think the United States has benefited from by virtue of your service on this commission. And an under-inclusive list is that you're a person of tremendous wisdom, of extraordinary character. Your judgment is impeccable and to be relied upon at every turn. You have a characteristic that is important of all successful lawyers and jurists, and I take it commissioners as well, which is you have a tremendous curiosity. And so although you know a great deal about the law and have shared it with us, you are always prepared to learn and to push into areas where you have something more to learn. And you build on your considerable base of knowledge, but come to new issues openly and in a way that encourages me and hopefully others to do the same. We've spoken about your dedication, but it's unwavering and extraordinary. And let us not forget that you are a person of good humor. In a number of ways, both in that you can laugh at and make a joke, but also that your presence brings a calm and a feeling of things will be okay because you are such a steady public servant. And so for your unwavering commitment, because you have served as an exemplar, as a colleague, as a public servant, as a lawyer, and as a person, I find and would like to announce publicly that your new job, whether or not you accept it, is that I intend to refer young lawyers to you as a mentor and as an exemplar of what one should do to walk as a professional in the legal community and to learn from your considerable contributions and all that you have shared and will share in the future. And I thank you for your service to the nation and for your friendship.
Commissioner Harriet?
I would like to thank the Vice Chair for her kindness and her thoughtfulness, which has been extraordinary. I believe you have served your country well. You have been an absolutely lovely colleague to have for these past 6 years. I mean, past 5.5 years. You didn't get your full 6 years. But I think that means that you should come and hang out with us at least for the next 6 months. But it has been just wonderful having you here, and I thank you very much.
Madam Chair?
Commissioner Kursnow?
Thank you. It's been an honor and a privilege and a pleasure to work with the Vice Chair. She really, I think, epitomizes what most people in public service aspire to. She brought great grace, intelligence, and civility to the Commission, and I'm really going to miss her.
Thank you. This is also the last business meeting for the current terms of Commissioners Harriet and Commissioner Kursnow, whose terms both end later this month. And because history and statutory requirements for commission bipartisanship, as well as Commissioner Harriet's own public postings, suggest they likely will return as appointees, I will not start eulogizing their time at this meeting, but we would, of course, thank them both for their service if they do, in fact, depart the commission. And for now, I look forward to the work that this commission will continue to produce as we reconstitute under reappointment and new appointment. If there is nothing further, I hereby adjourn this meeting at 11:22 Eastern Time. Thank you.
Bring on the Christmas carols.
Yes.